One, I'm going to revoke your bond, put you in jail. Second thing is I'm going to take away your privilege to drive. Do you understand?
Sure.
Do you see if he has a license?
Still running it, Your Honor. For some reason, slow.
Mr. Venegas, you are not allowed to drive unless you have a valid Texas driver license and liability insurance. That is also a part of your bond conditions. If I catch you driving and you don't have a license or you don't have insurance, it's not going to go well for you here. Do you understand?
Your Honor.
Okay. You have a lawyer. It is your responsibility to stay in touch with him, and he'll tell you when you have to come back. If he tells me he can't get a hold of you, then I'm going to issue for a warrant for your arrest. You pick up a new case, act a fool in the free world, I'm going to take it away.
I'm able to run it right now, Your Honor. It's not letting me on our system.
Joe, can you follow the same conditions on the racing?
Conditions.
Alright, so I'm going to have you sign a reset. After that, we'll have you take a seat in the jury box. I will get your bond conditions. We have you sign it, and after that, you'll be free to go.
Good morning, Your Honor. One of the protocols we have Chester and Blackburn regarding probable cause. I have issues with probable cause in this case.
Okay, let's do it.
So, officers were conducting an unrelated fatal accident investigation when they observed the defendant's vehicle traveling at a high rate of speed towards the blocked portion of the road. The officers saw the defendant disregard a barricade and were able to successfully get the defendant to stop by shouting verbal commands and utilizing their flashlight. Upon contact, the officer determined moderate fluid alcohol percentage, glassy eyes, watery bloodshot eyes, and slurred speech. The defendant admitted to having 3 drinks at a nearby bar and was temporarily detained. Standard filtered writings were conducted. GN 4 out of 6, walk-up 4 out of 8, one leg stand 2 out of 4. GICs were read and the defendant completed the breath. The results were .086 and .084. Your Honor, when you turn on the video and screen,
But remember, this is probable cause. I don't get access to all that stuff.
I understand it, Your Honor, but when the officer basically decided that he's going to arrest her, basically he puts her in the vehicle, and before any investigation is done, he says, I'm charging her. This is prior to basically any field sobriety test being done. She didn't have any slurred speech, Your Honor. No bloodshot red eyes at all. He said all the buzzwords to trigger probable cause. I'm asking the court to watch the video 5 minutes.
No. That's in for suppression here. This is a mere probable cause, right? Because I have to give them the ability to respond to your arguments. We can't do that in a probable cause. Like, you know what I mean? So, if you're saying it is as it is, see if they'll do a dispositive motion to suppress, where if you win, they'll dismiss. You know, but if you lose, you gotta plead, right? Otherwise, we can set it. But, you know, when you start getting into the video, when you start getting into the minutia of, well, she really didn't have this, she really didn't have that, I have to give them the ability to respond. I can't just rule on it, you know? Whether, you know, there was an actual traffic infraction, that's like problem, right? But when you start getting into the actual details of everything, I mean, that's for, you know, either a suppression or for trial. So ask them if they're good for, you know, dispositive. That's something that you want to do. Let me see. It's only 60 days old, so you've got some time, you know. I'm happy to, go forward with having her go forward. For probable cause purposes, you're getting into arguments, right? And I can't give them, I have to give them the ability to respond. You know?
Yeah.
Okay. Sorry. Okay. Hey, what's up? Hey,
Morning, Your Honor.
how are you?
Miss Lily Baba.
The last name.
Baba.
Ibarra. Okay. What's the word?
First bond. She has a bond set in this case because she was on no bond for the felonies last time we were here. But the state is going to post to a PR bond in this case because
She's being held at no bond upstairs.
I know, and the felony attorney is working on that. They resolved the felonies on Friday, and the bond was not relitigated up there.
She's going into a PTI. She's going into like a supervised, like a 1-year PTI upstairs.
And as part of that deal, we're going to get rid of our misdemeanor, but obviously she needs to get out in order to get into the PTI and everything.
The felony attorney knows about the bond issue. I don't know when she plans to address it, but I'm just here to get her out on the investigation.
Since it's going to be dismissed one way or the other with the felony PTI, so I try to make sure that our case isn't holding up the felony offers.
Is she here now? Do we have her?
She has a whole lot of felony.
You might bring her out. I mean, they don't even have a date set.
That's
Set for 120.
I know. I spoke to the felony attorney. It was a mess up on her part for sure, but I spoke to the felony attorney and she will go approach on it at some point. I mean,
Are you anticipating a PR bond upstairs?
I would assume so, yes, because she has a PTI, like the felonies have been resolved, so I would assume
Never
yes.
assume anything,
I know.
you know?
I know, and I can't speak for what happens in the felonies. I'm only on the misdemeanor, Your Honor, but
I can see that the agreements and its needs and everything. So
yeah,
it looks like we're moving towards that.
yeah.
I just want to make sure that we don't.
What do you want to set it for? Maybe like a week,
Yeah, that's fine.
and we'll see. Okay.
Fine.
Does she have history of like flight? Do you know? She's got.
Has never through flight. She lived in Houston most of her life. She's pregnant right now. She's 6 months pregnant, and essentially, we just kind of want
She has 2 prior assault cases. Both of those. Any flight in respect to those cases?
I'm not much. I should plan over
to.
here.
I don't think, based on what district clerk shows, no, Your Honor.
Just take a look. I don't see.
All right, so I'm much.
So she only has 1 prior assault. It looks like that one was dismissed. And this new one here, looks like it was charged assault of a hospital personnel, right?
Yeah, I got dismissed on Friday.
Did they refile it?
No,
Okay.
because it got claim dismissed, and then the PTI is for the assault on the officer, and I think mental health case, Your Honor.
I'm down with you. I'll grant you a PR bond.
Okay, thank you.
The only thing I'm going to ask is that she stays in touch with you, right?
Yes.
I'm not going to continue to do this. Like, if she gets out, she just takes off. I'm not going to do that,
Yeah.
And I'll admonish her.
Thank you, Your Honor. I guess she'll still come out, right?
Yeah, I need that for sure.
Yeah.
Who is our CW?
CW.
Hold on a second. We'll do that. Hold on. Sure. Tell me. Yeah.
Sure.
CW.
Okay.
So I'm trying to get the records from the sheriff's office. They finally got them to me.
You have everything you want.
I haven't had able to get through it all. It's like almost 600 pages.
It's going to be long. Okay. Good. Bless. You speak English, ma'am?
Yes, sir. Yes, Your Honor.
Sivar, I want you to understand and appreciate that you have a lot of lawyers that are going to bat for you now, trying to help you even get out. Your lawyer here is asking for a PR bond. You even have the state that's in agreement to get you a PR bond. The only thing that we're asking you to do is be safe to our community. Don't pick up any new cases and stay in contact with your lawyer. Right now, I'm going to grant you a PR bond, and I'm not going to do this over and over and over and over and over. I'm going to give you one chance to get out there and do the right thing, make the best of the chance that you're giving. But if you get out there and you just take off and you don't stay in contact with anyone and you pick up a new case, all bets off. Do you understand?
Your Honor.
I'm not asking for much. All I want is my community to be safe, for you to stay in contact with counsel. That's it. Okay, so I'll grant you the PR bond. Looks like the bond is already set. We're going to set it out for a week because you're still at no bond upstairs, so we don't know what's going to happen in your felony case. So we'll set it off for a week, and then we'll go from there. Okay?
Yes, Your Honor.
Do you have any questions?
Oh, God.
So tell me about this one here. Who's the complaining witness?
Dating relationship boyfriend.
Does he want to have contact with you?
He's not. We haven't really been. He hasn't been cooperative with, so I won't be able to tell you what he wants other than to drop parties. Really.
So I want you to understand that I am going to grant what's called a magic order for emergency protection that identifies Mr. Rodriguez as a protected individual. You cannot commit family violence or an assault against this person, commit an act in furtherance of an offense under section 42.072, which is the stalking statute. You cannot threaten, harass, use another person to communicate threat or harassing behavior, and you cannot be in possession of what? Do you understand?
Yes, Your Honor.
I'll take off the residential restriction just in case, but everything in the memo she shouldn't do anyways. All right, understand.
Yes, Your Honor. Thanks.
So I just had a quick question. We're set for trial tomorrow in ERB on a family violence case, and I just wanted to know logistics-wise, would we pick tomorrow and then start Wednesday, or if we have a jury tomorrow?
Are you really gonna go?
Yeah, it sounds like we're gonna go.
You hear this?
Okay. Sure.
I've got 7 other cases set for trial as well tomorrow in here.
Okay.
So let's see which one actually
Yeah,
goes. So technically, we pick on a Tuesday. Everything starts testimony on a Wednesday, and then we go. That's yes. Arsena, you were charged with interference with the emergency request for assistance. You were facing up to a year in jail and/or a $4,000 fine. It seems that probable cause has already been found in this case.
I don't know why would you.
Because he bonded out. I guess he's been AWOL, right?
Saying how to the judge. He had a felony of assault with family member that was dismissed or arrested.
Okay.
That's why he got out.
All right. So, are there any kind of bond conditions that you guys?
Holy moly is not something you want to hear from a judge. That's not courtroom sarcasm. That's judicial exhaustion. When a judge starts talking about community safety this early, that means the defendant's pattern is louder than his excuses. And here's the bigger issue. Bond is a privilege, not a reward. You keep picking up cases, that privilege disappears fast. Question for you. How many chances should someone get before accountability kicks in?